Be ready? Start. Learned Council for the District Cooperative Banks, however, submitted that the Reserve Bank of India must assure that the entire amount offered by the district cooperative banks for exchange after due verification in the form of demonetized notes will be duly replaced by commensurate amount of legal tender notes contemporary stop. The learned Attorney General on instructions submitted that the policy of placement of legal tender notes as applicable to public sector banks and other banks will be applied even in the case of district cooperative banks for exchange of demonetized currency with the legal tender currency stock. We accept the assurance given by the learned Attorney General in this behalf. Stop. The other board point was about extending the time limit for exemption for use of demonetized currency notes of rupees 500 and rupees 1000 at specified counters as per the relevant notifications issued in that behalf by the Reserve Bank of India. Stop. It was contended that the exemption period provided in the concerned notification is expiring. Stop. Hence, it will not be possible to deposit the demonetized notes at specific counters thereafter, even in case of emergency situation like hospitalization, travel by railway or air, etc. Stop. In our opinion, whether the exemption period should be extended or not must be best left to the judgment of the government of the day, with a hope that the government will be responsive and sensitive to the problems encountered by the common man. Stop. Accordingly, we decline the issue any interim direction to the government in the matter of extending the period of exemption and leave it open to the government to take appropriate decision in that behalf as may be advised. Stop. Stanza. The other serious grievance made by the petitioners is about the denial of right to withdraw the prescribed amount of rupees 24,000 per week per account holder, in spite of notification issued by the Reserve Bank of India permitting such withdrawal. Stop. It was submitted that if the government has issued such notification after due consideration, it is obliged to ensure that its commitment made under the said notification is implemented without any exception. Stop. The ground reality, however, contends learned counsel is that the banks are refusing to pay full amount of rupees 24,000 per account holder per week on the ground of non-availability of enough volume of legal tender currency stock. According to the learned Attorney General, the government has already made it imply clear that it would take around 50 days time to streamline the cash flow. Stop. That period is still not exhausted. Stop. He submits that as of now the Reserve Bank of India has been able to infuse around rupees 5 lakh of the new legal tender notes in the form of rupees 500 and rupees 2000, that is almost over 40% of the amount of demonetized notes already deposited with the banks. Stop. Further, the authorities are working to the best of their ability to diffuse the crisis of cash flow situation by printing new notes. Stop. Stanza. It is further submitted that for the nature of decision taken by the government to unearth the black money or unaccounted money and to dry up the terror fund and defeat the attempt of circulation of large scale counterfeit currency, maintaining complete secrecy of such a decision was imperative. Stop. For that reason, new currency notes could not be printed well in advance. Stop. He submits that the old demonetized notes will be replaced by new legal tender notes in the form of rupees 500 and rupees 2000 progressively in right earnest. Stop. Considering the stand taken by the learned Attorney General, we may commend to the authorities to fulfill their commitment made in terms of the stated notification permitting withdrawal of rupees 24,000 per account holder of the bank per week to the extent possible and review that decision periodically and take necessary corrective measures in that behalf. Stop Stencha. The trial court, after analyzing the evidence, found that there were few contradictions in the statement of PW1 and her daughter PW2 with regard to the period of stomach ache and the duration for which she was on medication by the local doctor, private chemist. Stop. However, in the opinion of the Sessions Court, these were very minor discrepancies. Stop. The Sessions Court noted that the prosecutrix was only 9 years old child when the incident happened and she was only 12 years of age when she deposed in the court, and therefore it could not be expected of her to report each and every fact by giving minute details. Stop. The trial court further observed that both the witnesses withstood the test of credibility, as even after undergoing detailed cross-examination their depositions on vital aspects remained firm and could not be shaken. Stop. Stencha. The main argument advanced by the defense before the trial court was that it was a case of inordinate delay where reporting to the police was 3 years after the incident. Stop. The trial court, however, was not convinced by this argument. Stop. In the judgment given by the trial court, detailed reasons are given which will be discussed at the appropriate stage by us as to how, in the given circumstances, the prosecution was able to explain the delay. Stop. Taking aid of various pronouncements of this court on this aspect, the trial court concluded that the said delay had not dented the case of the prosecution. Stop. Other argument of the defense that PW1, mother of the prosecutrix, had filed false complaint to implicate the respondent on account of family feud was also not found to be convincing. Stop. Stencha. In the ultimate analysis, the trial court believed the statement of the prosecutrix as true since it was supported by medical evidence on record. Stop. It was found to be trustworthy and not shrouded with any doubt. Stop. The trial court pointed out that the statement of PW8 clearly suggested that the prosecutrix was forcefully raped by the respondent, and as a result of that her hymen was ruptured and her external anal sphincter was also torn. Stop. Even internal sphincter was not continence. Stop. She found that anal sphincter of the prosecutrix was not functioning properly. Stop. In the opinion of PW8, on account of injury to the prosecutrix anal sphincter, she might be a sufferer throughout her life. Stop. Stencha. Another argument of the defense before the trial court was that it was impossible that such an incident would have occurred in the house where so many family members lived. Stop. In such circumstances, it could not be believed that the respondent would have taken the prosecutrix to the room on the first floor and committed sexual intercourse. Stop. This argument was also brushed aside by the trial court, pointing out that in her cross-examination, the prosecutrix has stated that the incident had taken place in the morning hours around 8 a.m. to 9 a.m. Stop. Female members of the family returned back to the house after 1 hour of the incident. Stop. The prosecutrix had stated that she had not disclosed about the incident to anyone since the respondent had threatened to kill her, and also did not disclose to her mother on phone out of fear. Stop. She was not conversant how to make a call on phone stop. The Sessions Court found that the testimony of the prosecutrix appeared to be true. Stop. It could not have been expected of a child of tender age. Stop. Over.